My name is Nia Chambers. I am 34 years old, and I built a business that my brother has spent 3 years telling people he built. I want to be precise about what that means before I tell you how it ended. I am not describing the kind of general credit-taking that happens in partnerships, the vagueness of language at networking events, the natural slippage between "we did this" and "I did this" that most professional relationships navigate with some friction and no lasting harm. I am describing a sustained, specific 3-year revision of our company's founding history that my brother Craig told to our family, our extended professional network, our industry contacts, and, in the weeks before the meeting I am going to describe, to the private equity firm that was considering acquiring us. The revision was consistent. He delivered it with the confident specificity of a person who had told it enough times that it had become his memory rather than his narrative. And I had said nothing about it for 3 years, in every room where I heard it, at every family dinner where some version of it was offered, at every industry event where a version of me had been subtracted from the founding story of something I had built. Not because I was afraid of Craig, not because I agreed with his version, not because I lacked the ability or the evidence to contradict it. Because I had a folder on my laptop with 73 pages of documentation, and I had been waiting for the right room. The right room was a conference table on the 14th floor of a building on South Tryon Street in Charlotte, North Carolina, on a Tuesday afternoon in September. 12 people, 2 partners from Harwick Capital, their lead analyst, their outside legal team. Craig, me, 2 of our operations staff. The meeting was a potential acquisition. The meeting was also, though nobody knew this except me and my attorney, the culmination of 3 years of careful preparation for exactly this kind of examination. The meeting started. 40 minutes in, a young analyst named Mr. Foster looked up from his notes and asked a technical question about the intellectual foundation of our methodology. Craig began to answer. He stopped. The room noticed. I opened my laptop. Let me tell you what I actually built, because the story cannot be understood without that foundation. 6 years before the September meeting, I was 28 years old and working as a digital strategy director at a mid-size marketing firm in Charlotte. I had been in the industry for 5 years, had built deep expertise in data-driven content architecture and paid media optimization, and had spent 3 years developing what I called an engagement architecture framework, a proprietary methodology for mapping digital customer touchpoints to conversion outcomes. The framework was mine in the specific documentable sense. I had developed it on my own time from my own training and observations, by studying what the industry was doing systematically wrong and building a model that addressed those failures at the structural level. I had presented an early version at a digital marketing conference in Atlanta 3 years before Chambers Digital was founded, under my name, with the framework's name on the title slide. I had applied it across client accounts at my employer, generating results I had documented. I had refined it continuously until, by the time Craig came to me with the idea of starting an agency together, the framework was a mature and tested methodology that could be reliably delivered and scaled. Craig's pitch was honest and accurate at the time. He had strong client relationships and business development capability. I had the methodology that would differentiate us from every other boutique digital shop in Charlotte. He could sell. I could deliver. The combination was real. We structured the company at 60% for me and 40% for Craig. Craig had proposed 50-50. I had declined and laid out in writing the rationale. The framework was the company's primary asset, and the company's ownership should reflect that. He accepted the split. We had a founding agreement drafted by an attorney. We had a separate IP assignment agreement in which I formally contributed the engagement architecture framework to the company as a pre-existing intellectual property contribution. Both documents were executed by both parties, reviewed by both parties' counsel, and notarized. Those 2 documents were the beginning of the folder. The business grew quickly, and the growth was traceable to the framework. In the first year, we landed 9 clients, primarily through Craig's network and a prospecting strategy, one designed specifically around the framework's documented outcomes. The approach worked because it was specific. I could show a prospective client exactly how the methodology addressed the gaps in their current digital strategy at a level of technical specificity that generic agencies couldn't match. Clients didn't just sign because the pitch was good. They stayed because the work produced results that exceeded what they had been getting. By the end of year 2, we had 27 clients, a team of 11, and a reputation that had been built on a specific deliverable. The framework. My framework. Craig was excellent at his part of the business. I want to say this clearly and mean it because the story I am telling is not about whether Craig contributed. He contributed substantially. Client development, relationship management, renewal conversations, board presentations, the easy warmth that made difficult meetings feel manageable. He had the specific ease of a person who moves through professional rooms without friction, and that ease had real commercial value. What he had not built was the thing those rooms were buying. The change, the shift in how he described the founding, in what he attributed to himself, was gradual enough that I could not point to a specific day it started. In the first 2 years, the attribution had been largely accurate. He introduced me as his co-founder in client settings. He described the methodology as mine when it came up. He gave credit where the business context made credit natural. What changed was the acquisition inquiry. 18 months before the September meeting, Harwick Capital made initial contact. Craig took the call. He did not tell me for 2 days. When I found out, from a mention in an email thread where I had been CC'd at the last moment, I said nothing about the 2-day gap. I said, "Tell me about the call." He described it as a preliminary inquiry that probably wouldn't go anywhere. He was wrong about that. By the end of year 5, the inquiry had become a serious process, and the process had made the narrative matter in a new way. When I found out about the call, I started paying a different kind of attention to how he described the business to other people. The first time I heard Craig tell someone I had exaggerated my role was at my Aunt Karen's birthday dinner in Huntsville, North Carolina, on a Saturday evening in October. I was coming back from the kitchen when I heard my name. My uncle Devonte was asking about the business, and Craig was answering. I stopped in the doorway. He said, "Nia's great at the execution side of things. The strategic vision was mine from the start. She took what I had developed and built the implementation around it. That's not a small thing, but it's different from originating the concept." His voice had the smooth ease of a man stating a correction, not making a claim. My uncle said, "I always figured you were the one who saw the opportunity first." Craig said, "The vision was there. Nia has always been the one to execute on it." I stood in the doorway long enough to hear the conversation move to something else. Then I went back to the kitchen and stayed until dinner was called. I ran the scenario in my head as I stood at the kitchen counter. I walk into the living room. I say that is not an accurate description. Craig says it is his recollection. My uncle looks at 2 siblings disagreeing about a business he has no information about. My aunt's birthday dinner becomes a dispute. Neither version of the story has documentation. The room decides based on social dynamics. Who is more charming, who is older, who the family is used to deferring to in moments of ambiguity. Craig was more charming. Craig was older. Craig was the one the family was used to deferring to. Not this room, I thought. After dinner, I opened the notes app on my phone and typed the first entry in what would become the attribution log. The date, the location, my uncle's name, Craig's words as close to verbatim as I could reconstruct. I had not yet decided what the log was for. I understood instinctively that it was the right thing to build. The folder existed before the birthday dinner in one form. After the birthday dinner, it became something different. Before, a file on my laptop containing the founding agreement, the IP assignment agreement, and the Atlanta conference presentation. The 3 documents that established the framework's origin and my ownership position. I had kept them the way any careful person keeps important documents, not as preparation for a specific conflict, but as the basic discipline of someone who understood that foundational records needed to be accessible. After, a structured, organized, growing document built for examination. The methodology record came first. I pulled together every document showing the engagement architecture framework's development. The conference presentation from Atlanta, the client case studies from my prior employer, the internal training materials I had brought to Chambers Digital at founding, 3 years of company-era methodology documents, showing its continuous evolution under my development. I organized them chronologically with a cover sheet identifying each document's date, source, and authorship. The record established a 9-year paper trail with my name on every piece of it. The client correspondence section came next. 3 years of emails in which I was the primary strategic point of contact. The person clients wrote to when they had questions about methodology, the person who designed the engagement architecture for new campaigns, the person whose name appeared in the documentation they received. Not because I was managing client relationships, Craig did that, but because the intellectual work behind the relationships was mine, and the paper trail of that work was continuous and clear. Then the attribution log. I kept it monthly, reviewing what I had heard and observed, dating each entry. Family events. Industry conferences where I had been present. Second-hand accounts from colleagues who had heard Craig's version in settings I wasn't in. The log was not emotional. It was factual. Who said what, when, to whom, as close to verbatim as I could manage. By the time I retained Ms. Reeves, the folder had grown to 51 pages. I want to say something about staying quiet, because it is the part of this story people have the hardest time understanding. The most common response I have gotten since the meeting from people who know the outline of what happened. Why didn't you just say something sooner? You had the documents. Why did you let it go on for 3 years? The honest answer is that staying quiet was not passive, and it was not avoidance. It was a strategic decision based on a clear-eyed assessment of what different responses would produce. If I had confronted Craig at my aunt's birthday dinner, I would have had an argument. 2 people, each claiming their version was correct, in a room of people who had no basis for evaluating the competing claims. The room would have defaulted to the version that fit their existing picture of us. Craig as the visionary older brother, me as the capable but secondary younger sister. My version would have been noted and then subjected to every unconscious filter the room carried. His version would have been defended by everyone who had already absorbed it. I did not want a room that adjudicated on personality and family dynamics. I wanted a room that adjudicated on documents. There is a specific kind of room where documents are what matters, where the question is not who is more convincing, but what the record says. A due diligence examination by a private equity firm is that room. The professionals doing the examination are paid to find out what is actually true. They examine records. They ask technical questions. They do not decide based on who tells the better story at lunch. Craig had told his story at lunch. I had the folder. I needed the room where the folder was the right kind of evidence. For 3 years, I built the folder and waited for the room. Waiting required a specific discipline I had not known I possessed until it was required of me. The discipline of continuing to show up to every family event and every industry gathering and every meeting with Craig while holding the documentation quietly, without using it prematurely, without signaling that I had anything at all. I attended my aunt's birthday dinner the following year, and the year after that. I attended 2 industry conferences where Craig's version was the version people had absorbed. I smiled and redirected and added to the log afterward. The folder was the answer I was not saying out loud. The room would come. I kept building. Ms. Reeves came into the picture 8 months before the September meeting. She was a business law and intellectual property attorney in Charlotte, recommended by my accountant as someone who had handled founding disputes in closely held companies. I had researched her practice area enough to know she was the right person before I called her. I brought the folder to our first meeting. She read it in the methodical way of a person who was processing for legal relevance rather than narrative impact, cross-referencing, making notes, returning to specific sections. When she finished, she said, "The founding documents are clean. 60% to you, 40% to him, with an IP assignment that specifically names the engagement architecture framework as your pre-existing intellectual property contributed to the company at founding." I said, "Yes." She said, "And the methodology record establishes the framework's development predating the company by 3 years, with consistent authorship documentation across the full period. The earliest document is the Atlanta conference presentation," I said. My name, the framework's name, 3 years before the company existed. She nodded. "I want to request the company's official records," she said. "Not what you have, the records held by the registered agent. The founding documents as filed and any amendments." "Why amendments specifically?" I said. She said, "Because when an acquisition is in process, people sometimes attempt to adjust the governance structure to improve their negotiating position. I want to know what the official record says before we proceed." I had not thought of this. "Can I request those records?" I said. "As a 60% shareholder," she said, "you have an absolute right to inspect the company's official records. I'll draft the request today." She sent the request that afternoon. The records arrived 9 days later. What I found in those records changed the picture in ways I had not anticipated. I had expected to find the founding documents intact. I had originals, and altering them without my knowledge would have been both difficult and illegal. What I had not expected was the possibility of a governance amendment. It had not been in my frame of reference because I had not imagined that Craig understood the company's operating agreement well enough to identify the specific clause that governed my consent rights. He had understood it, He had moved on it. The folder was about to acquire two of its most important sections. The official company records contained the founding agreement, the IP assignment, and the original operating agreement. All as I remembered them, all intact. No alterations. But there was also a document I had never seen. An amendment to the operating agreement, filed 14 months earlier, under Craig's signature alone. I read it 3 times at my kitchen table before I called Ms. Reeves. The amendment restructured the company's management authority over acquisition transactions. Under the original operating agreement, any transaction involving the sale or transfer of a company ownership stake exceeding 20% required the affirmative consent of members holding more than 50% of the ownership interest. Since I held 60%, my consent was effectively required for any significant acquisition deal. The amendment Craig had filed granted him, as the company's designated CEO, sole authority to negotiate and execute acquisition agreements on behalf of the company without requiring additional member consent. He had filed it 14 months ago. Harwick Capital's serious acquisition interest had begun 16 months ago. He had moved within 2 months of understanding that an acquisition process was developing, and he had moved to remove my consent requirement from the governance structure before I had legal counsel reviewing the records. Ms. Reeves said when I reached her, "This is what I was looking for." I said, "Can he do this?" She said, "No." Under the original operating agreement, a management authority change of this nature required member consent representing more than 50% of ownership interest. He cannot unilaterally amend this provision without your agreement. The amendment is procedurally defective and unenforceable. She paused. "But it tells us something important," she said. "He has been building not just a social narrative, but a legal structure to support it. He understood what an acquisition process would require, and he attempted to position himself before you were in a room with counsel who could identify it." The folder grew by 2 sections that evening. Section 8 was the amendment. Section 9 was Ms. Reeves's 3-page legal analysis of its defect, which she sent me the following morning, formally documented for the record. The hardest part of the 3 years was not any single moment. It was the accumulation. I want to be honest about what carrying this looked like from the inside, because the version of it that comes across in retrospect, the methodical documentation, the patient waiting, the disciplined folder, can sound colder and more controlled than it was. There were Sunday evenings when I sat in my apartment in Charlotte with the folder on my laptop and asked myself the question I had been asking for 3 years. Am I overreacting? There were family events where I watched Craig tell some version of the company's history and felt, under the calm I was maintaining, something that had no productive use but was very real. There were moments when the patience required cost me something that patience often costs, the energy of holding something correctly rather than releasing it. There was the industry conference in the second year where a colleague I respected told me she had heard that Craig was the strategic mind behind Chambers Digital, and asked, genuinely curious, what specifically my role was. I had answered correctly and professionally and driven home afterward with the specific weight of a person who understood that the false record was circulating independently now, not just in family rooms but in professional ones. There was the night I found the amendment. I sat at my kitchen table for an hour after finding it. Not reading it again, I had already read it 3 times. Sitting with the understanding of what it meant about the 3 years I had been navigating. The social revision had been disrespectful. The legal amendment was a different category entirely. It was a formal attempt to restructure my authority out of a process that would determine the value of what I had built, using a governance mechanism he did not have the standing to execute. I had gone to bed at 11. I had not slept until 2. What I had sat with in those hours was not anger exactly, though anger was present and was real. It was the specific recalibration of understanding that comes when a situation you thought you knew turns out to have a dimension you had not seen. I had thought Craig was revising the history socially. The amendment told me he had also been revising it legally. Those were different categories of what had happened. At 7 the next morning I was at my desk building the final sections of the folder. Methodically, without rushing. The same way I had built every previous section. Please take a minute to like and subscribe. Jordan had been watching all of this from the beginning. Jordan worked in content strategy at an agency in Charlotte. We had met at an industry conference 4 years earlier and had the kind of professional friendship that becomes genuinely close when you spend enough time being honest about the industry. They understood what Chambers Digital was, what the framework was, where it had come from, and had been watching Craig's narrative develop with the restrained frustration of someone who knows the true version and cannot make the relevant rooms hear it. We were on my back porch 2 weeks before the September meeting, coffee going cold in the specific way of conversations that are more important than the coffee. Jordan said, "He briefed them before the meeting." I said, "I know. I heard it from someone at a mutual event. He had lunch with the Harwick lead partner last week and presented his version of the company's history." "That's his right," I said. Jordan looked at me. "He's poisoning the well before you even walk in," they said. "You know that. He's giving his account without documentation," I said. "There's a difference between that and having the record. What he said at lunch is words. What I have is documents. In a room full of people doing acquisition due diligence, those are different kinds of evidence." "What if the question doesn't come?" Jordan said. "What if the meeting runs on narrative the whole time?" "Then I produce the founding documents," I said. "I don't need the question to open the folder. The question just makes the moment obvious and natural. The folder exists regardless of whether the question comes." Jordan held their coffee. "You've been preparing for this meeting for 3 years, they said. "No," I said. "I've been building accurate documentation for 3 years. The meeting is the room where accurate documentation gets examined by people whose job is to determine what is true. I've been building toward that examination. Not toward this specific meeting." Jordan said, "What's the difference?" I said, "The difference is I wasn't planning a confrontation. I was maintaining a record. The meeting is just where the record and the right examiners finally occupy the same room." The morning of the September meeting, I woke at 5:20 without an alarm. I made coffee in my apartment and sat at the kitchen table with the folder open on my laptop. Not reading it, I knew every section by then, every document, every date. I sat with it the way you sit with something you have built carefully over a long time before the moment it goes out into the world to do what it was built to do. 73 pages. Section 1. The founding agreement with ownership percentages, both signatures, attorney file stamp, notary seal. Section 2. The IP assignment agreement naming the engagement architecture framework as my pre-existing contribution, both signatures, attorney file stamp, notary seal. Section 3. The methodology record, 9 years of development history, beginning with the Atlanta conference presentation 3 years before the company's founding and running continuously through the present, every document dated and authored. Section 4. 3 years of client correspondence establishing my role as the primary strategic contact on every engagement the company had ever run. Section 5. The attribution log, 18 months of dated specific instances of Craig's revised narrative, as close to verbatim as I could document them. Section 6. The public record, industry articles, conference speaking credits, professional profiles, establishing my visible presence as a practitioner independent of the company's internal structure. Section 7. The timeline Ms. Reeves and I had built showing the relationship between Harwick Capital's acquisition inquiry timeline and the development of Craig's narrative escalation. Section 8. The invalid amendment. Section 9. Ms. Reeves's 3-page legal analysis of its procedural defect with the relevant operating agreement citations and the applicable Georgia business law statute. I closed the laptop. I had been building the folder for 3 years, and it was now complete. Every section organized, every document verified, every analysis reviewed by Ms. Reeves. The folder was ready in the specific way of something that has been built with enough care that there is nothing left to add. I got dressed carefully. Not performatively. I dressed the way I always dressed for important client meetings. The professional version of myself that the work had earned. I drove to South Tryon Street. The folder was on my laptop. The laptop was in my bag. The meeting was in 40 minutes. Craig was in the Harwick Capital lobby when I arrived. He was wearing the good navy blazer he reserved for significant client presentations. He had the specific ease of a man who has prepared thoroughly and believes the preparation will be sufficient. He smiled when he saw me, the particular smile of someone who has decided the meeting is already going well. "Ready," he said. "Yes," I said. I meant it in a way he did not understand yet. We took the elevator to the 14th floor. The Harwick Capital offices had the specific quality of places where significant decisions are made carefully. Clean lines, a conference table that seated 16, a presentation display, the particular stillness of a room that had been arranged for something. 2 partners, Mr. Harwick, the founding partner, and Ms. Chun, the operational partner. Their lead analyst, Mr. Foster, managing the presentation interface. Outside legal counsel, 2 people from a firm I recognized. Craig opened the meeting. He was good at this. I had always known he was good at this, and the goodness was genuine, not performed. He welcomed the room with warmth that was not manufactured. He described the company's trajectory with specific and accurate pride. He framed the acquisition opportunity with the fluency of someone who had been selling for 15 years. At the summary level, everything he said was accurate. At the level of attribution, it was the version I had been hearing for 3 years. I sat at the table and let him open. I had been letting him open rooms for 6 years. What I did while he opened this one was a different kind of work. I listened for the gaps, the moments where the description of what the company did reached the edge of what Craig actually understood about how it did it, and waited for the question that would arrive at that edge. Craig's description of the methodology had always been accurate about what it produced. He had spent 6 years watching it produce results, and he knew the results fluently. What he did not have was the why underneath the results, the theoretical architecture, the academic grounding, the conceptual model that explained not just what the methodology did but why it worked. The why was mine. I had built it, and in a room full of people who were evaluating whether to pay a significant sum for a company built around a proprietary methodology, the why was exactly the kind of question that would come. The first 20 minutes belonged to Craig. He walked the Harwick team through the company's growth trajectory. Client count, revenue progression, team expansion, market positioning. All accurate. He described the engagement architecture framework as a core differentiator, which was true, and as the strategic approach we developed, which was the version I had been noting in the attribution log for 18 months. Ms. Chin asked the first question. How had the methodology been applied in cross-vertical expansions, and what had the adaptation process looked like? Craig answered fluently. He described outcomes correctly. He spoke about the framework's flexibility in language that was accurate about the results. Mr. Harwick asked about competitive moat. What specifically prevented a well-resourced competitor from replicating the approach? Craig answered. He described the methodology's output differentiation accurately. I was watching Mr. Foster. He had barely spoken. He was an analyst, which meant his function was different from the partners. He was not evaluating the relationship or the vision. He was evaluating the substance. He had a printed document in front of him that I recognized as the company overview we had submitted, and he was cross-referencing Craig's answers against it with the specific attention of someone looking for the gap between the narrative and the technical reality. Mr. Foster looked up. He said, I'd like to understand the intellectual architecture of the framework itself, the underlying conceptual model, the theoretical basis that the methodology is built on. Walk me through how that model was developed and what it's grounded in. Craig said, the model was developed through a combination of. He stopped. Not dramatically. The stopping of a person who has arrived at the edge of what they actually know and cannot locate the next sentence, because the next sentence requires knowledge they do not have. The room noticed. I had been waiting 3 years for that 4-second silence. I said, May I? The room went still. Not the ordinary still of a pause between speakers. The specific still of a room that has just observed something that requires processing. The stopping of Craig's answer, the recognition that the stopping was meaningful, the recalibration of everyone at the table as to what they were looking at. I said it calmly, not as a challenge, not as a correction, as an offer. I'm the person who can answer this question. Would you like me to answer it? Mr. Foster said. Please. He said it without looking at Craig. The room went still in the specific way of people who have just observed something and are deciding what to make of it. Mr. Harwick looked at me. Ms. Chin looked at me. Mr. Foster looked at me, then at Craig, then back at me. Craig looked at me with an expression I had not seen on him before, not hostility, not relief, not calculation. Something between recognition and the particular stillness of a person understanding, in real time, that a moment they had been avoiding has arrived. I said, I'm the person who built the framework. I'm happy to walk you through the theoretical foundation. Mr. Foster said, Please. I answered for 14 minutes. I described the behavioral economics literature the framework was grounded in, the research on decision-making under uncertainty, the work on attention economics and choice architecture that I had drawn from in building the 3-phase conversion model. I named the specific researchers. I described the conference presentation in Atlanta where I had first presented the framework publicly 3 years before the company existed. I described how the theoretical model had been translated into a practical methodology through client application, and how 3 years of company work had refined and extended the original architecture. I was not performing expertise. I was answering from inside the work, which has a specific quality that is immediately distinguishable from someone who has learned a thing versus someone who built it. The language is different. The precision is different. The ability to move from the conceptual to the specific and back, without hesitation, is different. Mr. Foster was writing throughout. Ms. Chen was writing throughout. When I finished, there was a pause of about 5 seconds. Then Mr. Foster said, "The documentation submitted by your company lists Craig Chambers as the primary founder." I said, "The company was co-founded. The founding documents specify the ownership structure and each founder's contributions. I have those documents here." I opened the folder. 73 pages. The documentation that I had been building for 3 years, organized, indexed, ready for examination by exactly this kind of room. I had not brought it to make a case. I had brought it because an acquisition discussion about a company built around a proprietary methodology needed accurate founding documentation, and accurate founding documentation was what I had. The folder was not a weapon. It was the record. I placed 3 documents on the table. The founding agreement, the IP assignment agreement, a printed copy of the Atlanta conference presentation cover page, my name, the framework's name, the date, 3 years before Chambers Digital was incorporated. I set them in the center of the table without announcement, the way you set documents on a table when the documents speak clearly enough not to require introduction. Ms. Chen picked up the IP assignment first. She read it carefully, not skimmed read. I watched her eyes move through the operative clauses, the identification of the framework by name, the assignment language, the contribution value statement. She said, "The engagement architecture framework is identified here as pre-existing intellectual property developed by Nia Chambers, contributed to the company at founding as her founding contribution." "Yes," I said. Mr. Harwick picked up the founding agreement. He looked at the ownership percentages. He looked at both signatures. He set it down. "The ownership split is 60-40, he said. 60% to you." "Yes," I said. The split reflected the differential in founding contributions, specifically the pre-existing intellectual property that represents the company's primary commercial asset. The outside legal counsel, who had been quiet for most of the meeting, leaned forward. I said, "There's also a governance matter I want to flag before you proceed further." I placed the amendment on the table alongside Ms. Reeves's written analysis. The room went to a different kind of still. Mr. Harwick's outside legal counsel leaned forward. He picked up the amendment. He read it in the specific focused silence of a professional reading a document for legal implications, rather than narrative understanding. When he finished, he set it down and picked up Ms. Reeves's analysis. The room waited. Craig, across the table, was looking at the documents the way a person looks at something they had hoped would not appear in a room like this. The legal counsel read the analysis. Then he set it down and looked at Mr. Harwick. "This amendment is procedurally defective," he said. "The original operating agreement requires member consent exceeding 50% ownership for a management authority change of this scope. The 60% member did not sign. The amendment cannot be executed validly under these terms." Mr. Harwick said, "Craig, were you advised that this amendment required Nia's consent?" Craig said, "My understanding was that CEO authority covered operational governance decisions." The legal counsel said, "This isn't operational governance. This is a structural change to acquisition consent rights that is explicitly governed by the member consent provision in your operating agreement." The room was quiet. I said, "I'm prepared to proceed with the rescission as a condition of any further process." Mr. Harwick looked at Craig. Craig said, "Agreed." The outside legal counsel picked up the amendment and began reading. The partners waited. Mr. Foster was still writing. Craig, across the table, was looking at the amendment the way a person looks at something they had hoped would not appear. The legal counsel said, after 2 minutes of reading, "This amendment purports to grant sole acquisition authority to one party in a company where a majority shareholder did not consent." I said, "Under the original operating agreement, a management authority change of this nature required affirmative consent from members holding more than 50% of ownership interest. As the 60% owner, my consent was required. I was not informed of the amendment and did not sign it. It is procedurally defective under the original operating agreement and the applicable Georgia business statute. My attorney's written analysis is attached. The legal counsel read the analysis. Mr. Harwick said to Craig, "Were you aware this amendment was procedurally defective?" Craig said, "My understanding was that the CEO had authority to execute operational amendments." The legal counsel said, "Not amendments affecting member consent rights for major transactions. That requires member approval under standard operating agreement structure." He looked at his copy. "Your original agreement is explicit on this." Mr. Harwick looked at Craig. Craig was looking at the table. Mr. Harwick said, "I think we need a brief recess." The recess was 20 minutes. In those 20 minutes, Craig stood at the window with his phone and made calls. I sat at the table and answered a message from Ms. Reeves with 2 words: "Amendment flagged." She replied, "Stay steady." When the Harwick team returned, their posture had changed in the specific way of people who have had a conversation in the hallway and arrived at a shared position. Mr. Harwick said, "We need to proceed on the basis of accurate governance documentation. That means the amendment needs to be formally rescinded as a condition of any further process." He looked at Craig. "Are you prepared to agree to that?" he said. Craig said, "Yes." The formal meeting ended 40 minutes after that exchange. There was no acquisition decision. That was not going to happen at a single initial meeting, and both sides understood the formal process. What the meeting produced was an agreement from Harwick Capital to proceed to full due diligence on the basis of the founding documents as presented, with the invalid amendment rescinded, and with the company's ownership and contribution history accurately represented going forward. Craig and I rode the elevator down in silence. In the lobby, before we separated to our cars, he said, "You had that folder ready?" "Yes," I said. "How long?" "The full organized version," I said. "About 2.5 years. The underlying documents have existed since we founded the company." He was quiet. "I'm not going to pretend I don't understand what you did in there," he said. "What did I do?" I said. "You let me tell my version for 3 years," he said. "And then you chose this room to correct it." "I chose the room where accurate documentation would be examined by people equipped to evaluate it," I said. "I was not interested in arguing with you at Aunt Karen's birthday dinner. I was interested in the record being accurate in the context where accuracy mattered commercially and legally." He said, "That's a long time to wait." "It is," I said. I did not apologize for the waiting. I drove home. My mother called 2 days after the meeting. Craig had called her first. I knew this because she said Craig called me about what happened at the business meeting in the opening of the call, which meant his version had arrived before mine. I said, "What did he tell you?" "He said the meeting was complicated," she said. "He said you presented documents." "I presented the company's founding documents," I said. "The ones both of us signed 6 years ago." She was quiet in the way my mother is quiet when she is working something out. "He also told me," she said carefully, "that you had been building a file about him. For years. I've been maintaining accurate documentation of the company's founding history and my role in it," I said. I started doing that more systematically when I began hearing Craig's version of that history described in ways that weren't accurate. "He said you were building a case." "The documents are the company's founding documents," I said. "The IP assignment, the founding agreement, my conference presentation from 3 years before the company existed with my name on it. Those aren't a case against Craig, they're the accurate record of what happened." She was quiet again. "Why didn't you say something to us?" she said. "To your father and me." "Years ago." I had expected this question. "Because telling you without the documents would have been my version against his," I said. "And Craig is the one you've always heard first. He's charming and he's present and he tells good stories. If I had come to you and said Craig is describing the business in ways that aren't accurate, you would have heard both versions and tried to find the truth in the middle. The truth is not in the middle. The truth is in the documents." She said nothing for a long moment. Then she said, "I should have asked to see the documents years ago." "Yes," I said. "You should have. It was not an accusation. It was just accurate." Craig and I had the real conversation 10 days after the meeting. Not on the phone. He asked to come to my apartment, which told me he was approaching the conversation with a seriousness that phone distance would have made easier to avoid. I said yes because I had been building toward an honest conversation for 3 years, and the meeting had created the conditions where one was finally possible. He sat at my kitchen table. He said, "I need to tell you something honest." I said, "Go ahead." He said, "I've been telling myself a version of the founding that put me at the center of it. Not because I sat down one day and decided to lie. It happened gradually. I would describe the company to someone, and I would emphasize the parts one understood and minimize the parts one didn't. And every time I did that, the story shifted a little, and after 2 years the shifted version was what I remembered. I said, "I know that's how it happened." "Does that make it better?" he said. "It makes it more understandable," I said. "It doesn't make it less damaging." 3 years of describing the framework as your strategic vision, in professional contexts, moved through the industry. People I respect formed their understanding of this company based on your version. The private equity firm that wants to acquire us was briefed on your version before the meeting. He was quiet. "The amendment," he said. "That was different," I said. "I know," he said. "The amendment was," I told myself it was a procedural efficiency. A CEO governance structure. I told myself it wasn't about you. "But it was time to the acquisition," I said. "Yes," he said. "It was." He looked at his hands. "I've been building a position," he said. I didn't call it that. But that's what I was doing. "Yes," I said. "And I was building a different kind of position. One that was just accurate." He said, "Why did you wait? Why didn't you use the folder earlier?" I said, "Because earlier wasn't the right room. The right room was where the documents would be examined by people whose job was to determine what was true, not to choose between two family members. You can argue with your sister. You can't argue with a notarized IP assignment." He was quiet for a long time. Then he said, "I can work with this. If you're willing." I said, "I'm willing if the foundation is accurate going forward. Not your version, not my version. The documented version." He said, "The documented version." "Yes," I said. The formal due diligence process began 30 days after the September meeting. Harwick Capital assigned a 4-person team. They spent 8 weeks examining the company's records, client relationships, operational systems, financial history, and intellectual property foundation. They were thorough in the specific way of professionals who do this work for a living and know exactly what they are looking for, and where companies of this type tend to have undisclosed complexity. They found no undisclosed complexity because I had been maintaining accurate documentation for 3 years. They examined the methodology record and confirmed the framework's origin. They reviewed the client correspondence and confirmed the attribution of strategic work. They examined the founding documents and the rescinded amendment, confirmed the governance structure, and verified that the company's ownership and contribution history matched the legal record. The due diligence summary, which Ms. Reeves helped me review, described the company accurately. My role, co-founder and chief methodology officer. Craig's role, co-founder and chief executive officer. Both accurate. Both real. Both, for the first time in the company's public-facing representation, correctly attributed. The framework, my framework, the methodology I had built over 3 years before the company existed and refined over 6 years inside it, was listed as the company's primary intellectual asset, with its origin accurately described. Ms. Reeves read the summary and said, "The record is accurate. I had been working toward those 4 words for 3 years. Not specifically those words. I had not known what form the confirmation would take. I had known that if the folder was complete and accurate, and if it reached the right room, the room would produce an accurate finding. The finding was accurate. The record was accurate. That was what I had built toward." I read the summary twice. Then I called Ms. Reeves. She said, "The record is accurate." Said it in the specific professional register of someone who has watched cases like this go wrong at the documentation stage, and is noting that this one did not. I said, "Thank you. For everything." She said, "You came in with a complete file. I organized the legal framework around what you had already built. The documentation was yours." That was the most accurate description of the 3 years I had heard. I thanked her again and ended the call. Then I closed the laptop and sat at the kitchen table in the specific quiet of a finished project. The record was accurate. That was what I had been building toward. That was enough. Jordan brought dinner to my apartment the Friday after the due diligence summary came back. They brought it without being asked, the way close friends bring food when they understand that a person has been running on adrenaline for weeks and needs something that is just an ordinary evening. We ate at the kitchen table, the same table where I had built the folder, where I had read the amendment, where Craig had sat and finally said the honest thing, and Jordan said, "Talk to me about how you feel." I thought about it honestly. "Different," I said. "I've been carrying a specific weight for 3 years. The weight of knowing and not having the room yet. That weight is gone. Good different, they said. Mostly, I said. There's also the grief part. The marriage was real for 4 years. I stopped. Wrong story. Jordan smiled. The business was real, I said. It still is. What Craig and I built together was genuinely good, and the 2 years before the narrative shifted were actually a real partnership. I don't want to revise that because of what came after. But what came after was real too, Jordan said. Yes, I said. Both things are true simultaneously. That's the specific difficulty of family businesses. The genuine thing and the complicated thing are made of the same material. Jordan looked at the table for a moment. The folder, they said. Yes. You know what the folder actually was? I said. Tell me. Confidence, they said. Not arrogance. The specific confidence of a person who knows exactly what they built and is willing to wait for the room where the knowing is enough. You weren't angry. You weren't vindictive. You weren't even urgent about it. You just maintained the accurate record and waited for the room that would know what to do with it. I sat with that. The patience was the whole thing, I said. The patience was everything, Jordan said. We sat with that for a moment. You know what I keep thinking about? Jordan said. All the rooms where he told his version and you were in the room and you said nothing. That takes something most people don't have. It takes the belief that the right room is coming, I said. If you don't believe the right room is coming, if you think the family dinner is the best chance you're ever going to get, then you fight for the family dinner. I believed the right room was coming, so I waited for it. Jordan looked at me. And the folder gave you the ability to wait, they said. Yes, I said. The folder is what made the patience possible. I wasn't waiting in the dark. I was waiting with the documentation. Craig and I had the real conversation 10 days after the meeting. He asked to come to my apartment, which told me he was approaching it seriously. I said yes. He sat across from me at the kitchen table and said, I need to tell you something honest. I said, go ahead. He said, I've been telling myself a version of the founding that put me at the center of it. Not because I sat down one day and decided to lie. It happened gradually. I would describe the company to someone and emphasize what I understood and minimize what I didn't, and every time I did that the story shifted slightly, and after 2 years the shifted version was what I remembered. I said, I know that's how it happened. Does that make it better? He said. It makes it more understandable, I said. It doesn't make it less damaging. 3 years of describing the framework as your strategic vision, in professional contexts, moved through the industry. People I respect formed their understanding of this company based on your version. The private equity firm was briefed on your version before the meeting. He was quiet. The amendment, he said. That was different, I said. I know, he said. The amendment was, I told myself it was a procedural efficiency. I told myself it wasn't about you. But it was time to the acquisition, I said. Yes, it was. He looked at his hands. The framework, he said. Tell me what I've gotten wrong about it specifically. Not the ownership. I understand the ownership. The description. What have I been saying that wasn't accurate? It was not the defensive question I had prepared for. It was the genuine one. The question of a person who has been told their map was wrong and wants to understand where the errors were. I told him. I described the theoretical foundation he had never fully understood. The behavioral economics grounding, the academic literature, the architectural decisions that made the methodology work rather than simply produce results. I described it not as a correction, but as an explanation. The way I would explain it to a client asking the right question for the first time. He listened fully, not defensively, not with the half attention of someone waiting to counter, with the attention of someone receiving information they had been missing for 6 years. When I finished, he said, I should have asked you to explain this at the beginning. Yes, I said. You should have. Neither statement was an accusation. They were just accurate. And we were building on accuracy now. He said, I can work with this. If you're willing. I said, I'm willing if the foundation is accurate going forward. The documented version. Not either of our narratives. He said, the documented version. Yes, I said. Aunt Linda, my father's older sister, who had been a bookkeeper for 30 years and had a practical relationship with financial reality that most of my family did not, called me the week after my father did. She said, I heard about the meeting from your father. I said, what did he tell you? He said you walked into a room with a folder, and the folder said something different from what Craig had been saying, she said. That's a fair summary, I said. She said, good. Just that. Not a question. Not an elaboration. Good. said in the tone of someone who has watched families navigate these situations for decades and understands, without sentimentality, what accurate documentation is worth. I said, "You're not surprised. I watched your grandmother keep records her entire life," she said. "Every receipt, every letter, every document." She said paper doesn't argue with you. Paper just says what it says and stays there. She paused. "I always thought you were the one in this family who understood that." I thought about the folder. 73 pages built over 3 years, sitting on a laptop, waiting for the right room. "She would have approved of the methodology record," I said. Aunt Linda said, "She would have approved of all of it. The patients especially." "Why the patients specifically?" I said. "Because impatient people fight," she said. "Patient people build. And building is what lasts." I held that. "Thank you," I said. "Don't thank me," she said. "Keep the folder. Don't delete it just because this part is over. The accurate record needs to exist somewhere permanently. It's in the company's official due diligence record now," I said. "Good," she said again. Same word. Same tone. I thought about what it meant that Aunt Linda's response to everything I had told her, the 3 years, the folder, the meeting, the outcome, was that single word delivered twice. Good. Not wow, not I'm so proud, not that was brave. Good. As though it was the expected outcome of correct behavior. As though she had always known this was what accurate documentation would produce if maintained with sufficient patience and deployed in the right room. Maybe she had. Maybe that was what 30 years of keeping records taught you about what records were for. 6 weeks after the September meeting, Chambers Digital and Harwick Capital signed a letter of intent. The acquisition structure Harwick proposed reflected the company's actual ownership and contribution history. My 60% was reflected in the transaction. The framework, the engagement architecture methodology I had built over 9 years, was valued as the company's primary intellectual asset, and its valuation was reflected in the deal structure accordingly. Craig's 40% was reflected accurately. His contributions, the client network, the 6 years of relationship management, the operational leadership, were recognized and valued. The structure was not punitive. It was accurate. I had never wanted to punish Craig. I want to say this again because it is true and because the story is easy to read as a story about settling scores. I did not build the folder to defeat my brother. I built it because an acquisition transaction was being structured on the basis of information I knew to be incomplete, and a transaction structured on incomplete information produces inaccurate outcomes for everyone, including the party who believed the inaccurate information served their interests. Craig had 64 million reasons, in the preliminary valuation, to be glad the record was accurate. His 40% of what Chambers Digital actually was worth more than his 100% of the version he had been describing would have produced in a deal built on misrepresentation. I did not say this to him. He understood it. We were still in the early stages of rebuilding something honest between us. That work was slower than the acquisition process and would not be completed by a letter of intent. But it was real work, and we were both doing it. And that was what I had wanted when I had opened the laptop in the conference room and placed the documents on the table. Not the folder's victory. The beginning of accuracy. Accuracy between Craig and me. Accuracy in the company's official record. Accuracy in how the business that we had both built, differently, in different proportions, with different kinds of contribution, was described and valued going forward. I had spent 3 years maintaining the accurate record while the inaccurate version circulated. The accurate version was now the version in the official record. That was what the folder had been building toward from the day I had opened my laptop after the birthday dinner and started organizing documents into something that would survive examination. The examination had arrived. The folder had survived it. The record was accurate. That was enough. I think about the 4 seconds. Craig stopped mid-sentence, and the room went silent for approximately 4 seconds. That is not very long. 4 seconds is the pause before someone answers a question, the beat at the end of a sentence when the room is deciding how to respond. Those 4 seconds were the return on 3 years of preparation. I had not been preparing for a dramatic moment. I had been preparing for an accurate examination. The 4 seconds were just the visible expression of the examination arriving at the edge of what the narrative could support and requiring something the narrative did not have. The knowledge that lives inside the actual work. You cannot fake being inside the work. You can describe it. You can learn the language of it. You can speak about outcomes with authority. But when a room of sophisticated professionals asks you to walk them through the intellectual foundation of a methodology, the theoretical basis, the academic grounding, the conceptual architecture, the gap between describing a thing and having built it becomes audible. The gap became audible in 4 seconds. And I had 73 pages in a folder that were ready for exactly that moment. I think about the person I was 3 years ago, standing in the doorway of my aunt's break room, hearing Craig tell my uncle that I had taken his concept and built out the implementation. I think about the decision I made in that doorway. Not this room. I think about every dinner and every event and every secondhand account I absorbed and documented rather than confronted, and I think about how the absorbing and the documenting felt at the time. Not powerful, not strategic, just costly. The cost of patience. The cost of building instead of arguing. And then I think about the folder. 73 pages. The founding agreement. The IP assignment. The Atlanta conference presentation with my name on it from 3 years before the company existed. The amendment that had tried to erase my consent and had been procedurally defective since the day it was filed. The room where documentation is what matters had arrived. The documentation had done what documentation does. The truth did not need to be the loudest thing in the room. It just needed to be the most documented. And when the meeting started, and the question was asked, and the 4-second silence arrived, the documentation was ready. It had always been ready. Let them have the room. Let them brief the partner over lunch. Let them tell their version at every family dinner for 3 years. Build the folder. Maintain the record. Wait for the room where documentation is what matters. Because that room always comes. And when it does, it will ask one question. The question that only the person who actually built it can answer. For seconds of silence. And then you open the file. The truth doesn't need to be the loudest thing in the room. It just needs to be the most documented.